Ladies and gentlemen, dear guests, thank you for coming and attending this conference here in Belgrade. I'm very honored and I'm very glad to be a chair of this fifth session of our International Student Conference about history of criminal law this year. And this session is somehow a specific one because we are dealing completely with the topics which are rooted in history of Polish law. Well, in Serbia, we are not all very familiar with these topics, so I'm sure it will be very interesting for all of you. The first of our guests who are coming from Poland and who will take words today is our colleague, Mr. Franciszek Ignacy Fortuna, who is coming from University of Warsaw and Catholic University of Leuven. And he will discuss about very interesting subject. He will reconsider here two penal codifications, the Penal Code of the Kingdom of Poland and the Code of Main and Corrective Penalties, as well as their modifications and changes introduced over the years. I suppose that some kind of specific enlightenment will be about political context, about economic circumstances, and everything others, which was a kind of prerequisition for enactment of these codes. So the floor is yours, and we are listening to you very carefully.
Okay, thank you for the great introduction and for the floor. I'm really grateful that I can give my speech today. Especially I'm grateful for Polish panel, because it's not so obvious that we can talk about Polish criminal law outside of our country. Much has already been written about the history of Polish criminal law. However, due to the variety of legal systems under which Poles lived in the 19th century, many research topics still remain unexplored. It seems that it's an interesting issue, the evolution of penalties in the codifications of the Congress Kingdom of Poland. The subject of the study is two penal codifications, the Penal Code of the Kingdom of Poland from 1818 and the Code of Main and Corrective Penalties from 1847, as well as all their modifications, of course. But the analysis of this development of these institutions of punishment should be based on the broader historical context of the complicated realities of the Polish lands under Russian rule. This will make it possible to answer research questions. How did penalties evolve in the penal codifications? How did penalties affect people? And that's the most important one for me, to what extent were they a political tool and a method used to repress uncooperative subjects? Okay, so first, few words about Congress Kingdom of Poland. From the 16th to 18th century in early modern Europe, there was a huge and powerful state in Central Eastern Europe, Polish-Lithuanian Commonwealth, which is usually called in Europe. Weakened by numerous wars and internal issues, in 18th century it fell under the sway of neighboring powers, Russia, Prussia, and Austria. And in 1795 it ceased to exist, torn apart by these three neighboring countries. The Poles lost their state, but surprisingly did not stop fighting for it. Poland is not yet lost, sang the Polish soldiers in service of France, hoping for the liberation of their homeland. Napoleon gave hope to the Poles because, according to the official propaganda of the French Empire, the wars fought with Russia were called Polish Wars. Their goal was to, at least in propaganda, to rebuild the Polish-Lithuanian Commonwealth. This goal did not materialize, of course, due to the defeat of the French Emperor, but the Polish question was still an important issue for European powers. So the Congress of Vienna in 1815 decided on a compromise solution, creating a small but formally independent Polish state under the rule of the Russian Emperor. Okay. And now in 1818, the Congress Kingdom of Poland gained their own code. For the first period of its existence, it was characterized by legal dualism in terms of criminal law, because in one part there was a Prussian Landrecht, and in other part Austrian Franciscan was in power. So after several years of work, the Legislative Commission succeeded in creating a new criminal regulation common to both parts of the state. Thus, in 1818, the Penal Code of the Kingdom of Poland was enacted. This work combined French and Prussian influences, although the greatest influence came from the Austrian Franciscan and Polish pre-partition criminal law traditions. The main penalties were the death penalty, life imprisonment in a fortified prison, imprisonment in a fortified prison for 10 to 20 years, and heavy imprisonment for 3 to 10 years. Correctional punishments, on the other hand, included imprisonment from 8 days to 3 years, fines of 40 to 2,000 zloty, and corporal punishment, flogging, but only in cases indicated by law. It means that nobility was excluded from this punishment. And finally, there were some police penalties like police custody, fines, and caning, up to 16 strokes. One of the most interesting aspects of the penalties in the code was those related to religiosity. Promulgated on 28th July, the penal code and even the penal codifications that followed were pillar of intolerant religious policy. They combated atheism, sectarianism, and the growth of non-Christian communities. Over time, they also significantly restricted religious propaganda of all confessions except the Orthodox, and the holding of services of any recognized religion and the mocking of objects of worship by speech, deed, and writing. The offenses mentioned above were punishable by 3 to 10 years of heavy imprisonment. Persons who persuaded Christians to abandon their religion and who founded or attempted to establish sects also risked criminal liability. The aspect of the application of the law, I think it's somewhat similar to the issues referred to the previous panel by Mr. Piotr Romaniuk. Is worth noting. Existing and legalized religious associations were persecuted even if they had formal permits for their activities. For example, there was a case of the Hasidim, Jews living in Poland since the 18th century, who in 1823 obtained permission from the governors of the Kingdom of Poland, General Józef Zajączek, to meet for religious worship. But anyway, they received the following instruction from the authorities. The sect of Hasidim was allowed to perform services in houses. When, however, Commission does not see any justification for this decision to extend to the free gathering of Jews from different neighborhoods, as far as in any place they can complete this together among themselves. And the coming from distant parts for this purpose not only exposed them to the unnecessary costs, but moreover, as a contrary to police regulations and facilitating vagrancy, which could not be suffered by. The penal code of the Kingdom of Poland can be considered the result of compromise. It contains some modern elements, such as division of offenses into felonies, misdemeanors, and offenses which had already been present in legislation of the Duchy of Warsaw. But on the other hand, it retained archaic corporal punishment, including flogging, the preservation of which was one of the main demands of the nobility. Therefore, it is included in the group of codes of the so-called transitional era from feudalism to capitalism. Now back to history. The Congress Kingdom was, according to the granted constitution, a political entity independent from Russia. The only common element was the ruler. Aleksander I was both Emperor of Russia and King of Poland. The kingdom had, for example, its own judiciary system or superbly trained army. However, in reality, the constitution of Kingdom of Poland was not respected neither by Tsar nor by his representatives. In the 1820s, the situation deteriorated to such an extent that the secret police unlawfully persecuted representatives of the Polish national movement, sending them to Siberia or hard labor. Tension in the nation grew, especially as the vast majority of the former Polish territories still remained within the borders of neighboring powers, because the Congress Kingdom of Poland was only like a small part of the previous great and big Polish-Lithuanian Commonwealth. The result of this process was the spontaneous outbreak of the November Uprising. As a result of this insurrection in 1830, the Polish Sejm, which was the lower chamber of Polish parliament, deposed the king, thus starting the Polish-Russian War. Despite the panic that the war seemed to cause in Russian general staff and the huge losses inflicted on the Russian army, Poland surrendered to Russia's numerical and supply superiority. The defeat began a process of violent and brutal Russification of the lands of the kingdom. One of the consequences of these events was also a change in the criminal laws applicable in the Congress Kingdom. They were significantly expanded and sharpened in the Code of Main and Corrective Penalties, which abolished the penal code of the Kingdom of Poland and introduced legal tools of repression against activists or sympathizers of national liberation circles. This act was a decisive step backwards in terms of the solutions it adopted. The punishment system was also further developed. The code implemented the so-called theory of discouragement. Its severity was to discourage subjects from opposing the Tsarist authorities in any way. This was to be achieved, among other things, by an almost unbelievably complex and extensive system of punishments. The new code included the death penalty, the punishment of hard labor in Siberia with indefinite settlement thereafter, together with stigmatization and flogging of 80 to 200 strokes. The latter applied only, of course, to those not exempted from corporal punishments. It was called katorga. Another one, exile to settlement in Siberia combined with the flogging of 40 to 80 times. Exile to settlement in the Caucasus. In addition, if each of the above-mentioned punishment was accompanied by deprivation of all civil rights of the convicted person concerning his or her condition. Corrective punishments were exile to settlement in Siberia without the right of return, with the possibility of imprisonment, obligation to work, or exile to settlement in remote imperial gubernia, also combined with imprisonment. Imprisonment in fortress, and I could go on and go on. It's really a large scale of complicated penalties. The three most serious offenses were punishable by death: treason against the person of the emperor, it was Article 241; rebellion against the supreme authority, Article 249; and treason against the state, Article 253. Some scholars used to say that it's only three situations where offenses were punishable by death, but the sources say that it is important to know the element of application of the law. I mean, the three prerequisites indicated before were interpreted extremely broadly to use them to repress political opponents, primarily representatives of the Polish national liberation movement. And this code from 1847 was in fact kind of modification of Russian prototype from 1845. Moreover, the Code of Major and Corrective Penalties extended the prohibition of religious propaganda in such a way that it was forbidden to convert Orthodox persons to any religion. And it's worth noting that, of course, simply the only big minority, religious minority in Poland, which were Orthodox, were Russians. Like, it's quite a political decision. Clergy of non-Orthodox denominations were not allowed to provide religious services to them, to non-Orthodox, to Orthodox people, under the threat of severe penalties. According to these provisions, adherents of all religions were obliged to prevent the Orthodox from deviating from their faith. Penalized were, among others, abandoning Orthodoxy or preventing voluntary conversion to Orthodoxy, and it was not defined exactly. Not preventing wards and family members from abandoning Orthodoxy. And for example, parents who baptized their children in the Catholic rite were punished by having children taken away and given to the Orthodox relatives, if they existed, or even to a state-appointed guardian. For me, it sounds like some extreme cases from Norwegian legal system now. In extreme cases, a person wishing to convert a follower of the ruling religion was threatened with deprivation of all rights and exile to Siberia and hard labor up to 15 years. So the analysis of this transformation of the criminal law in force in the lands of the Polish Congressional Kingdom had to be carried out and has to be carried out against a broader historical background, because in this context of the Poles' national liberation struggle for freedom and independence, the legal codifications imposed by Russia should be understood as an instrument of political repression. The way to achieve the planned absorption of the kingdom into the empire was to unify the legal system. Repressive and deterrent in nature, brutal and relatively backward legal codifications were to increase this. Given the much weaker effects of the Russification in the Congress Kingdom of Poland than in other Polish areas of the Russian Empire, one might be tempted to conclude that the author's goals were not achieved. So thank you for your attention, and I'm open, of course, to any questions after it.
Thank you very much, Mr. Fortuna. And our next speaker comes from University of Warsaw, Faculty of Law and Administration. It's Mr. Aleksander Świercz. Unfortunately, he was not able to come here and to be attended in person, so he will address us via our WebEx program. Is he here? Yes, he is. And he will present us something more about that penalty in the Second Polish Republic, meaning especially introducing Penal Code of 1932. So, Mr. Świercz, not the floor, but the screen is yours, and we are listening to you.
Thank you so much. My first question is, can you hear me?
I'm afraid that we cannot hear you properly. Just a second, please.
Okay, it's better right now.
Yes.
Okay, thank you so much. So I'm really glad to be here with you virtually. I could have had so many interesting papers. Unfortunately, as said, I'm not with you in person. Even though I would do my best to give you some details about death penalty and its development in the Second Republic of Poland. So from today's perspective, the topic is kind of historical, because death penalty is abolished in very most of European countries, as it is in Poland. And this actual current legal status is guaranteed by a row of acts of law, with the European Convention of Human Rights at the head. What is, however, interesting is that the death penalty is, according to last according to this evaluation, is advocated by more than half of Polish citizens, which means that death penalty has been or was for ages used, and it was a crucial part of the penal system, and the execution of penalty was not suspended even at the time of rapid transition and changing state structures as it was in the Second Republic of Polish. Due to the rapid transition and changing state structures I mentioned, let me break the chronological development, and let me start with the Polish penal code from 1932. And in this act of law, death penalty was a type of so-called basic penalty according to Article 37, and then it was specified that the punishment would be suspended by hanging. That was what Article 38 used to guarantee. Being sentenced to death was furthermore bound with the loss of public rights and civil rights of honor, which was stated in Article 47. The penal code enumerated only 5 crimes death penalty could be used for, and what is even more interesting is that 4 of them used to have a political nature. The first one, that's Article 93, Paragraph 1, depriving the Polish state of its independent existence or to detach part of its territory. Then in Article 94, assassination of the President of the Republic of Poland. The third one, Article 101, it was for serving in the army of a foreign state and for participation in military operations against the Polish state. And the fourth one, the fourth case, it was participation in a military operation against the Polish state in time of war without belonging to a foreign army. Last but not least, death penalty was reserved to a murder which was established by Article 225. Yes. What is interesting, there is no gender nor age limitation of threatening of servicing death penalty, but according to the statistics, which are unfortunately not complete, so maybe something is missing. There's only one case. A woman was sentenced to death penalty, and it is calculated, it is estimated, because the data is incomplete, that more than 1,500 death penalty was sentenced, and that's the number of people served to death. That's the general, that's what the state of penal code, but the Polish lawmaker decided to enumerate as several crimes threatened with the punishment with the death penalty, not by the penal code, but by a few decrees of President of the Republic of Poland, and the crimes that were indicated on in these acts are, for example, disclosing a state secret to a foreign government. It was serving in the purpose of defense or armed defenses, and finally, for a shorter period of time, it was corruption that was threatened by death penalty. It was only between the year 1920 and 1923, so at the very beginning of development of newly born Polish state. What can be considered as crucial, that it was not only that it was also summary court that could sentence to death penalty, and in fact that the punishment, the death penalty, was used. So people were sentenced to death penalty more in summary courts procedure than in a normal one. Here I tried to find the data. Not all of them are complete, but what is for sure, that by summary court between years 1919 and 1944, it was 1,144 people who were sentenced to death, and 805 were killed. So in most of cases, the punishment were done. The difference between the number is because the President of the Republic of Poland or formal, the so-called Naczelnik Państwa, had act of mercy for the whole period of time of existing the Second Polish Republic. Unfortunately, all the data that could tell us how often the penalty was sentenced by standard courts is not sure, but it is established by historians that it happened about twice as often, but that's rather a historical assumption. And unfortunately, it is unknown what was the crime people were sentenced for death penalty for, because such of data was never collected. The solution from the year 1932 that was a solution like of a Polish origin, but as I stated at the very beginning, the servicing punishment, including death penalty, has been done also in time of rapid state transition. And actually, what I do consider as the most interesting is that between year 1918 and 1942, so before the establishing of penal code, there were 4 different penal systems that were sources of law in Poland. In the former territories of Russian Empire, it was the penal code of the year 1903. Tagansev Code, by the name of its author. In Germany, or in German Empire, in former territories of German Empire, it was the so-called Reichsstrafgesetzbuch, which was established in year 1871. And finally, in the territories of the former Austro-Hungarian Empire, the modernized Franciscana was a source of law. I mentioned 4 penal systems. The 4th one, it was an Hungarian law, but it was enforced only in small area of the territory of the Second Republic of Poland. Interestingly, what was reserved for death penalty in the, let's say, Polish penal code from the year 1942 is more or less the same that was stated in foreign acts of law that were in force in the Second Republic of Poland. So there were mostly crimes against states, crimes of political nature. Obviously, some differences could be seen. So let me give you an example that by the German Empire law, it was not hanging, but it was cutting a head, which was how literally the death penalty was exercised. And obviously, that was not only the acts of foreign law, so this former empire's law that were in force in the territory of Poland, but also some Polish rules. And as an example of that, one may mention what is I consider as important to mention is that till the year 1927, the punishment was administered by soldiers. So let me just, as I try to justify it, to explain why it was, it is because most of the crimes that were threatened by death penalty was crimes of political nature, which was an urgent case in a newly born country. So, just to summarize, it seems that according to legal status, the death penalty was an extraordinary punishment. It was reserved. To really to do some special crimes. As said, most of them, that was the crimes of against the state of a political nature, and then a murder as a crime which is in our culture considered to be the most serious one. What is worthy to mention is that let's say so that lawmaker reserve death penalty only for really hard crimes. However, it seems so, on the other hand, that in practice courts were willing to sentence capital punishment. Just keep in mind that summary court was the courts that sentenced to death penalty mostly, or at least twice more than standard courts. The lawmaker tried to extend the application of death penalty also by military courts, and the military courts, the regulation I was discussing, it was about like general courts, not military one. The military could sentence to death in very many cases. Just keep in mind that during especially at the first year of the Second Polish Republic, Poland was a country which constantly had a war with other countries. And just to summarize and to try to explain how it was so why the legal status was different than what courts did in practice, I consider it's like a difficult political situation, and the fact that the Second Republic of Poland was a state of both external and internal conflicts, as well as that's what I began my presentation with. There was a strong social expectation to administer such kind of punishment. So just keep in mind that even today, there are more advocates of death penalty, more of society advocates for that, even though it is banned. So maybe it could be a conclusion that what is the responsibility of lawmaker, and what we can learn by the history of law, that sometimes the social expectations should not be taken into consideration by a responsible lawmaker. And let me just finish my my speech with this sentence. And if you do have any questions, I would be more than happy to answer them at the discussion part. Thank you so much.
Thank you, Mr. Świercz. And we have another topic and another speaker. It is Mr. Kacper Paszyński, who is coming from University of Szczecin, Faculty of Law and Administration. And he will tell something more about legal nature, advantages and disadvantages of the right of pardon. So the floor is yours.
I need a computer.
Okay.
Presentation.
Do you need any help with
So thank you much. Thank you very much for the floor. Thank you for the possibility of performing the presentation here. Thank you for the organizers for the great organization of the conference. Without further ado, I would like to start my presentation about right of pardon in Poland throughout the years. I will mostly focus on the 20th and 21st century, as it is the most interesting period, in my opinion, for the discussing of that topic. But before that, let's say something about the right of pardon in general. So let's define that term. So basically, it is the authority to free the convicts from their punishment, or at least mitigate that punishment in some way, or also to change the punishment to some other punishment that is less severe than the punishment that was sentenced first. In most legal systems, that authority was given to the bodies that are traditionally connected with the executive power. However, there are some exemptions in history and also today. In history, let's say, for example, the Athens ecclesia had the right to pardon convicts from their punishments. In most cases, it is the right of pardon is given to the monarch or president of the country only in the penal cases. However, for example, Louis XIV, the King of France, was able to pardon people from the sentences that was sentenced in the civil procedures. Not every civil procedure, but at least in some. So that's a very interesting exemption. And what is even more interesting is that the right of pardon is one of the oldest legal institutions known to the mankind. If we look at it, it was present in Mesopotamia when King Hammurabi could perform the right of pardon, or even in ancient Egypt. At the very beginning, it was probably because it was present in those legal systems because of the fact that king or pharaoh was a supreme ruler of the territory. Everything in under his rule, let's shortcut that and say belonged to him. So he was also the head of the adjudicative power that we know today. Therefore, it is not a surprise that he was able also to overrule or change every sentence that was given by other authorities. And therefore, and from that perspective, it is not surprising. Maybe it is even more surprising that that institution lasted for thousands of years and is still present in our culture. Its usage of the right of pardon shall be based on some humanitarian or justice values that courts may not take into account while giving the sentence to the convict, and therefore it's above the legal system. The values that are being taken into the consideration while giving the right of pardon are not based on the legal system, but on some other system. So it may lead to some controversies later on. So the right of pardon in Poland, let's move to that. It was present almost since the beginning of the Polish states, as of course the Polish tribes were in some way similar to the other tribes where the right of pardon was present, because the ruler of the tribe also in many cases had some adjudicative power. Therefore, it is also not a surprise that he could overrule or change or give a mercy to some people. But what is not very popular, what was not very popular, surprisingly, during the elective monarchy era in Poland, the right of pardon was given to the Sejm. So it was the body of legislative power, and it was mainly because of its superior position in that time in Polish state. And now let's move into the right of pardon in Poland in 20th century, the most interesting part of that institution. So every Polish constitution in the 20th century had given the right of pardon to the head of the state. Its usage could lead to total remission of the punishment, leniency, changing the punishment, or even conditionally suspension of the sentence. So the usage of that institution was quite broad, and scope of application of the right of pardon differed depending on the axiological basis of the constitution that was in power at the very time. So let's give some examples. There we have the quotations from the constitutions of the first, chronologically, the March Constitution. The President of the Republic is vested with the right to remit and mitigate punishment, as well to counsel the effects of a criminal court adjudication in individual cases. The President may not apply the right of pardon to ministers convicted as a result of indictment by the same, so the legislative body. We see here that the right of pardon could be given only to people that were convicted by the courts, not by other disciplinary commissions, for example. Also, the president could not apply it to the ministers, so there were a lot of the field to use it in a political way. Moreover, theoretically, the decision of the president needed to be counter-signatured by the minister. However, in practice, it didn't happen. So the president could pardon it without without any other body. Then we have a Constitutional Act of April 23, 1935. That constitution was totally different from the March Constitution because its axiology was totally different and was based not on a liberal democracy, but more than strong, let's even say authoritarian rule of a president. And there we see the President of the Republic has the power by an act of pardon to remit or mitigate the punishment imposed on the convicted person by a final sentence, or to abolish the effect of the conviction. And then we see that it didn't have to be the court sentence. It could be, for example, disciplinary commission. And there was a case that advocate who was sentenced by the disciplinary commission was pardoned by the president. Also, there was he could pardon everyone, even the ministers convicted who were convicts sentenced by the state tribunal. So no limitations because president had the supreme power in the state in that time. And the Constitution of the Republic of Poland of July 22, 1952. Some historical background. It was a communist constitution that was even personally amended by Stalin, by the way. And that constitution did not create the body of the president. The head of the state was the collective body called the Council of State, and the Council of State could apply the right of pardon. So very laconic information, very laconic norm, and in most cases it could pardon almost everyone, like in the Constitutional Act of April 1935. So there are some controversies about that, because in most cases the right of pardon was used in trivial cases where the sentences were not so harsh and there was no sense to punish the person for example, I don't know, stealing the wood from the forest. So it wasn't based on humanitarian or justice values rather than the triviality of the case. Moreover, since the April Constitution and it became like a tool of a penal law, not the constitutional law, it lost its traditional character. And what is probably the most the worst thing about the right of pardon in Polish history was its usage during the communist regime. As you may or may not know, there were a lot of let's say fake trials against the people who were fighting in the Second World War in order to restitute the Polish state and who were against the communist regime. Sometimes those trials were, let's say, justified in the way that those people were really the enemies of the communist state, but sometimes the only reason that those people were prosecuted was their pro-independence activity in the past and not in the present. So, for example, in that manner, the state council did not grant the right of pardon to the General Fildorf Nil, who actually did not want to overthrow the communist regime in Poland. He just fought in the Second World War. He wanted to then live a peaceful life. He was the enemy of the state in the scope of the government. So he was sentenced to death. There was no justice in the trial, and he was not pardoned by the competent body. And now the right of pardon in the current Polish constitution from 1997. So only the president has the right of pardon, and the Article 139, as it is on the presentation, the president of the republic shall exercise the right of pardon. The right of pardon shall not be applied to persons convicted by the state tribunal. So it is also very broad. Its usage is broad. Nevertheless, there are some limitations as to the, in practice, ministers who were sentenced by the state tribunal for their crimes connected with their offices. And the procedure of applying of the right of pardon is contained in the Act of June, the Code of 1997, the Code of Criminal Procedure. However, the president does not have to obey those code because the right of pardon is given to him in constitution. So in fact, he can act however he likes with the granting or deciding not to grant the right of pardon. And there are a lot of controversies connected to the right of pardon even today in Poland. For example, President Lech Kwaśniewski, Aleksander Kwaśniewski pardoned the person that he, in the case that he didn't even knew about. He was just given the paper with the approval opinion to pardon that person, and he pardoned a murderer. And in that case, there was really like no circumstances to grant that pardon. And the other, for example, his president Lech Wałęsa pardoned heads of the one of organized crime groups who were very violent and brought a lot of misery to the Poland at that time in early 90s. And those people later claimed that it was possible due to the bribe given to the one of the president's officials. So the social expectations were not met, and the social opinion was not very happy about that pardon. We've also seen last-minute pardon. Last-minute pardon is a pardon in the last days or months of reigning of the president. It is also common in the USA and also in Poland. What was even worse, that cases had a political background, so president just pardoned the people who were familiar to him and who were like being active in the same political group as he did. And one of the newest cases and one of the also most controversial cases in Polish constitutional debate is the pardoning of Mariusz Kamiński, a former head of Central Anti-Corruption Bureau, and he was accused of exceeding his powers in one of the cases that he was performing. And it was, of course, a very political case, but what is more important, Mariusz Kamiński was sentenced only by the court of the first instance. The sentence was not final, and it could be overruled by the second instance judgment. So in the terms of penal law, he was not guilty, and even though he was pardoned. Therefore, serious questions arose around that, and the Supreme Court, Polish Supreme Court, decided that it is not possible to pardon a person who is not sentenced by the final judgment. However, the Constitutional Tribunal sentenced differently and said that it is possible for the president to pardon the person who is not yet sentenced by the final sentence, and that situation is just unacceptable, because in fact the president may also pardon someone like for future crime, because it is logically the same, to be quite honest. So heading to the conclusions, right of pardon is present in Polish legal system for the very long period of time, since the very beginning of the existence of the Polish state. In a lot of, so nowadays it is mostly in the constitution because of some traditional aspects, because it was always in the Polish legal system. So let's allow it to be even further. As it was mentioned, in the 20th and 21st century, right of pardon was often not executed in a manner it meant to be, because like it was used in the political cases, it was used very often, sometimes also because of bribery and so on. As I also said about the bribery, those people should not be pardoned. They were, and as I said about General Fildorf-Nil, he wasn't pardoned, even though he should be, because his trial was injustice in the way that we can't even imagine. And I think that we may say that the right of pardon is a serious interruption of the executive power into the adjudicative branch, and therefore it should be reconsidered if we shall allow for such destroying, let's even say, the balance of powers in modern day constitution. I think we shall rely on the judges and courts that would take into the account more humanitarian and justice aspects into their sentences. So thank you very much for your attention, and I'm open to the questions if they will arise.
Thank you very much, Kacper. And the last speaker and last presentation for this session is coming from Ms. Agata Starkowska, who will tell us something more about political, economical, and of course, legal background, which was behind the Polish system, regulation of Polish system of penalties during the 20th and 21st century. Okay.
Yeah. Do you see? Oh, at the beginning, I would like to thank for the possibility to participate in such an interesting conference. My presentation is the last one in that session, so I promise I will try not to take much time. Moreover, I want to apologize for simplifying the topic a little bit, but as you see, the title seems to be very wide. So I feel that it will be more beneficial for all of us to focus on some essential remarks. My main purpose is to treat Polish example as a kind of a perspective from which we can analyze the punishment, the institution that has a double nature. The first one is philosophical and the second is just practical. So having taken those two perspectives into consideration, I prepared a schedule of the presentation. At first, as I've written in my abstract, I'm going to go through the theories of the punishment that were put in order in Polish doctrine by Katarzyna Sójka-Zielińska. Then I will delve into specific penal codes from Polish history from 1932, 1969, and 1997, taking into account three issues, which means the historical background, the catalog of punishments, and main functions of codes penalties. And finally, I'm going to consider also some current amendments that are discussed nowadays in Poland, which might consequently imply some material conclusions. So the philosophical theories of the penalty are divided into two main groups, the absolute theories and the relative ones. The absolute theories, in which we distinguish some examples like the moral retribution theory made by Kant and dialectic retribution theory made by Hegel. The second one is, for me personally, very interesting because it stems from the remark that the negation of law is the crime, and the punishment is a kind of negation of lawlessness. So it is very interesting perspective, I think. But in general, the absolute theories we can put in one sentence, which conveys the content of these theories. And the sentence sounds like, let him be punished because he has sinned. The second category of theories of the punishment is the relative theories. They are also named as utilitarian ones. We have, for instance, prevention theory made by Feuerbach or improvement theory made by Jeremy Bentham. These two categories of theories were mainly present in the science in 19th and 20th century, but they had a source in the Enlightenment era, actually. The division, which you can see, was initiated by Hugo Grotius, who connected the punishment with two general bases. One of them was the equity, and the second one was the utility. It can therefore be said that the differentiating factor between the absolute theories and the utilitarian ones is the value that needs to be realized by them to a greater or lesser extent. What I want to underline now is that the Polish doctrine was trying to be in the middle of the conflict between these two main theories. Edmund Krzymuski, who also participated in legislating the penal code from 1932, claimed that a fair punishment based on the idea of retribution for crime already carries in itself the capacity to become an institution of social benefit. This is because it is the most effective way of preventing people's minds from blurring the distinction between acts which are worthy of punishment and those which are supposed to be free from it. And actually, this golden mean was applied in the punishments regulations, which you will notice in a moment. And now just one sentence about the reason of my choice when it comes to this part of Polish history. Obviously, the 20th century is interesting because of various periods which it includes. I mean the interwar period, the People's Republic of Poland period, and the time from 1989, so the time after the process of political transformation in Poland. But what is more crucial in the context of the topic that I touch is that the common thing for all of these periods is a mental fight for the independence. In the interwar period, there was an obvious need to unify the law and legislate own new regulations. In the time of People's Republic of Poland, there was a fight with the communist domination, and now we can actually notice something like a fight for the independence in law, which from time to time is not free from the arbitrariness. Okay, so carrying on. It is worth giving you some facts because when we look through the codifications, the political impact can be also visible, and we are able to recognize the ratio legis of the regulations only in the light of the historical background. Or we can just even make a conclusion that some circumstances were definitely not influential. But the atmosphere in 1932 was connected with the need to restoring the statehood and unify existing legal orders. Before 1932 in Poland, there have been maintained codes from the partitions, the Austrian Code, Russian Criminal Code, and the Criminal Code of the German Reich. Somewhere was also Hungarian law dominating, I mean, on the theory of Spish and Orava, actually. In 1990, there was established the Codification Commission, which includes the Commission's criminal division, which was represented by surnames like Makarewicz, Makowski, and Edmund Krzymuski, who has also has been already mentioned at the beginning of my presentation. The code came into force in September, and it is often said that the penal code from 1932 was such a modern code. Psychiatrists worked on it, and there were a lot of foreign consultations. So we can say that this code was one of the biggest Polish law success in the previous century. I was going to tell you something about the general principles of this code, but I think that I will omit it now. So if you have a question to this point, I will be open, but I think that I will tell you a few words about the catalog of punishments, which is more important now. You should know that we divide these penalties into two groups: basic penalties and additional ones. Then I will focus only on the first group because it has more sense when it comes to the comparison between codifications from the previous century. So basic penalties in the Makarewicz code were the death penalty, the deprivation of liberty, and the fine. It should be underlined that in the penal code from 1932, there were two types of deprivation of liberty. One of them was the imprisonment, and its purpose was the spiritual regeneration of the offender. So it was mentioned in some commentaries that I read. And the second type was the detention. This kind of punishment leads us to the pedagogical side of upbringing or resocialize of the offender. There were mentioned some correctional measures for prisoners, like cultural or educational activities or some organization of work, physical education also. So there was also a death penalty, but this topic was also touched by one of the speakers. So I will only say that some commentaries say that the main purpose of this type of penalty was rendering the offender harmless, just like that. And going to the next slide, I will focus on the penal code from 1969. The 1969 penal code was created during the period of People's Republic of Poland, when our country was under Russian domination. This aspect also resonates at the level of the system of penalties, among which those which were provided for offenses against the state and public order were significantly high. The catalogue of penalties was a little bit different from Makarewicz's code. The basic penalties were the death penalty also, the deprivation of liberty, but there we have only one form of this punishment, but we have two forms of the other punishment, I mean the restriction of liberty. We can distinguish the unpaid work or the deduction from the salary. It was a novelty when we compare it to the previous code. And also we have a fine, like a punishment, and the novelty was also a punishment of 25 years imprisonment. Okay, so there's, as I said, there is no need to focus on the additional penalties because there were very similar in each of the analyzed codes. So I omit them on purpose now. So summing up now these two codes, I can point at some differences and similarities. So three of them are actually that in 1969, there was still the division into basic and additional ones, penalties, of course. There was the new type of the punishment, I mean the restriction of liability, and there was, we can notice also the lack of the division in the privation of freedom, which was in the code from 1932. Okay, so now the next code. Yeah. So when it comes to the current regulations, I will focus this time on the drawbacks that are pointed by the Polish law doctrine, because this perspective shows that the passage of time is not a guarantee of some better regulations based on mistakes made by previous generations. So concentrating on the penalties only, we ought to point that sometimes in Polish system, sometimes the Polish system is criticized for the objective of liberalization. So the goal in 1997 was to have as few prisoners as possible, but the search for the lowest possible minimum sentences leads to the extraordinary leniency, you can say. So crimes have been turned into misdemeanors. Unfortunately, it has been forgotten actually that we have actually three kinds of penalties. One of them is threatened, the second one is administrated, and the third one is enforced. So the second problem with the code from 1997 is that the harsh punishment was considered not as sensible as inevitable punishment. And this statement, I think, is a kind of a myth, because in Poland, actually, inevitability It's kind of a wish, I think, not a true standard. Okay, so when it comes to the catalog of penalties in this code, we should know that it was similar to the previous one, but without the division into basic and additional penalties. So the additional penalties were replaced by the new category named penal measures. So, for example, there was measures like deprivation of public rights, disqualification from driving, and some others. Okay, so you can look at the slide and see which penalties were in this code. And now I will carry on with my presentation. And only one sentence about nowadays reforms, because it is more connected with this slide. In Poland, there are discussed some changes in the penalty system nowadays. When it comes to the imprisonment, the upper limit will be now 30 years. So previously, the maximum was 15 years, and it has been also possible to sentence somebody to 25 years imprisonment or for life. Another change is that the authorities want to create something like a life imprisonment without the parole. And finally, there are going to be some increased penalties for rape and other sexual offenses. As you see, Polish system of penalties is going to become more strict and less reasonable, I think. For me, it is actually hard to find a difference between life imprisonment without the parole and even the death penalty. I try to find an utilitarian function of this punishment basing on the relative theories that I was talking about, but it is hard for me now. And now, finally, some conclusions. Regardless of the specific period, the law is used by the authorities or someone who came into force as an instrument. As we see, the punishment is such a prone institution which enables them to manipulate the society. So, for instance, in 1932, authoritarian authorities used some safeguards, named also as precautionary measures, in criminal law to fight with inconvenient opposition. In 1969, the authorities of the People's Republic of Poland frequently convicted for crimes against the state and public order. And nowadays, we notice fast and undeniably not diligent amendments which don't realize current punishment's functions. So the punishment is therefore a powerful tool in philosophical terms, but in practice, it shows many weaknesses. Where the arbitrariness comes into play, the values, especially the noble ones, become less noticeable, and the crucial role is being played by the materialistic interests, regardless if it is a communist system or a capitalism. So, thanks for your attention. If you have any questions, I'm open for them. So.
Thank you, Agata, and let me express one more time my gratefulness to all participants who took part in this PANA session, as you named it at the beginning. And I cannot but remember of Professor Dimitrije Matić, a famous Serbian scholar of 19th century, who was led by his pan-Slavic feelings until the end of his life, and who specifically was interested in cooperation with his Polish colleagues. So I'm sure that Professor Matić would be proud of us today, and also that we may not have right now some deeper academic cooperation. I hope that this panel, this session, could be a start of something like that in the near future. So the floor was ours. Right now the floor is yours, but just let me remind you one more thing. After this session, a lunch is beginning. So I have to remind you one another very common sentence in theory of rhetorics, which can be literally translated as the barbecue is cooling. So we are listening to your questions. Our participants will give you their answers, but please do not be very extensive. Yes, please.
Jakub Nowak, Master University of Brno. I have one short note for the third speaker, just that the same right of pardon exists in the Czech Republic for the same period of time, and we have very similar problems with it. It is usually called relic of a monarchy right now, and there are serious discussions if it shouldn't be moved from the president to, for example, Minister of Justice or something like that. And for the second speaker, I noticed the very high number of, is the second speaker still here? I don't think so. Okay, so I think I'll skip that one in favor of the lunch. Thank you.
Yes, please.
Thank you, but it is quite interesting here. So in Poland there is basically no such discussion, and it's a shame. At least I don't see the heated debate about the right of pardon. Nevertheless, maybe we'll follow our Czech colleagues in that manner in some time. At least I hope so.
Okay, any other questions? I think there is a okay, yes, please.
Yeah, after such introduction about the lunch hour, I feared to ask my question, but I had it prepared, so I'm gonna be as quick as possible. I have a question to I'm sorry, what? Regarding the right of pardon. I'm sorry, Kacper, right? Okay, so I have a question to you because you said, and it's right, of course, that the president may use this right however he wants because it's a prerogative, of course. But you also mentioned a case of President Paszyński using his right of pardon with an early prepared document that he was given, right? He signed it. Okay, so I think it would be hard to disagree that he somehow misused this power because he should consider it right to use his right of pardon. But you also said that he pardoned a murderer, so there were no circumstances for the use of the right of pardon. Then what are the circumstances? Because I just see kind of a discrepancy. It's a prerogative, so are there even any circumstances since a person was judged and there was a sentence? So what do you think about this?
Yeah, so it was some shortcut. Of course, he can do whatever he likes, and the president, so he can pardon everyone he likes. But as I said, it's a very old institution, and traditionally we have some circumstances that are that should be taken into account while pardoning someone. And that particular case shown that very often the president does not take into account those circumstances. So it was mainly, as I said, some humanitarian aspects or some justice aspects. For example, there was one, I think, some good example of using the right of pardon correctly in the interwar Poland, where Sergiusz Paszyński, who was once a Polish spy in the Soviet Union, and then a robber and a smuggler, he was pardoned for those deeds like robbery and smuggling the goods throughout the border. So he was sentenced to death, and he was pardoned thanks to his the things that he did for Polish espionage. But in that particular case of Aleksander Paszyński, the person that was pardoned, he was just a regular murderer, and probably Aleksander Kwaśniewski was not aware about that person, the details of that case, and it was he pardoned him because the Minister of Justice or the General Prosecutor just gave him the right papers, and so he just signed it. And so basically, the president can do whatever he wants, but he should do what the tradition told him to do. So yeah.
Okay, thank you.
You're welcome.
Thank you. Nina?
Just a very brief one question and one comment for Agata. I was curious, since you were talking about contemporary reforms and the strictening of punishments in the Polish system, how strict is the judicial practice in Poland? In general, I don't mean for extreme cases like mass murder and things like that, but in Serbia, for example, we do have relatively strict punishments prescribed in the laws, but the judges are generally fairly mild and lenient. And the comment just regarding the difference between lifetime imprisonment with no pardon and the death penalty, in the unlikely case that some new evidence comes up and it turns out that he's not guilty, in the first case you can let him go, in the second you can't do anything.
So thank you for the question. So in Poland, actually, the judges try to always use the law which can be the punishment which can be the lowest one, I think. So the tendency is, as you said, like in Serbia, but the authorities nowadays, which we have, try to make our system more strict, I think, because it also stems from the tendency to the arbitrariness, as I said. But answering to your question, so the tendency is to use the punishment which could be the lowest possible in the case.
Okay, any other? Okay, if there's no one interested, we will make a short break, around 1 hour right now, and you are all invited to join us here in our coffee club to have something for lunch. And I suppose that 6th session will begin for an hour approximately. Thank you very much once again.